Hello, I'm John Hurd. I've been representing Social Security, Disability, and SSI claimants for over 30 years, and I'm a named partner in Hurd & Smith. Right now I'd like to visit with you about errors in the decision by the administrative law judge, which, if you can bring them to the attention of the Appeals Council, may allow your case to be sent back for a new hearing. There are certain specific duties that the administrative law judge has, and if the administrative law judge fails to address one of those duties in his or her decision or in his or her handling of your Social Security hearing, and if you can demonstrate that to the Appeals Council, which is the part of the Social Security Administration that reviews decisions by the administrative law judges, then you very likely will be able to have that case sent back and obtain another hearing, possibly before the same administrative law judge or possibly before a different one. So, for example, if you appear at a hearing without a lawyer or other representative, the administrative law judge has a duty to notify you that you have a right to counsel or to representation. And if the administrative law judge says nothing about that and then just proceeds into the hearing, you very possibly could persuade the Appeals Council to send the case back because the administrative law judge failed to advise you that you did have a right to have a hearing. Administrative law judges sometimes will not do that because they don't want the hearing to be delayed, because they're anxious to get as many hearings done each week and each month as they possibly can, which is laudable because we do want the judges to get as caught up as possible on this terrible backlog of hearings. But nevertheless, the judge has a duty to let you know that you have a right to have a lawyer or non-lawyer representative at that hearing, and if the judge fails to do that, you may have grounds for the case being sent back. Now, other possible grounds are exhibits that you submitted in the case that never made it into the record, that never became part of the evidence for the judge to consider. Or maybe they were submitted and included in the exhibits, but when you read the decision, the administrative law judge doesn't comment in any way on the evidence that you added, giving the impression that the administrative law judge didn't read it or didn't consider it. Let's assume, for example, that you've got a severe medical condition and that you obtain medical evidence that you submit the day of the hearing or shortly before the hearing, and it demonstrates that your condition has gotten much worse and is impairing you to the point that you clearly couldn't work. Well, obviously, it's very important that the administrative law judge consider that evidence, but if the written decision doesn't demonstrate that the judge did consider the evidence, because again, the evidence, the exhibit that the evidence was made into doesn't show up in the list of exhibits, or possibly there is no list of exhibits attached, which itself is a procedural error, or even if it is listed as an exhibit, reading the decision demonstrates that the judge did not consider it because he or she makes no reference to the findings of that that treating physician, then you have a very good ground that your case should be sent back so that that important evidence can be properly considered. Another possibility regarding evidence is the judge might send you for what's called a consultative examination after your hearing. This frequently happens where the judge feels that there's not enough evidence in the case to decide one way or another whether you're disabled. Perhaps you have a back condition that maybe has shown some improvement, and it's been quite a while since you had medical treatment. So the judge wants to see what a consultative examiner, an orthopedic or other medical doctor who examines you would say about how you're doing now today. So after the hearing, the judge sends you out to a consultative exam. A month or so later, the decision, or rather the report from the doctor is returned to the administrative law judge and it gets put in your file. The judge reads the case and decides to deny your case without sending you a copy of that consultative examination report. If that happens, you have almost automatic grounds for a new hearing, because the judge has an obligation to send you a copy of that consultative exam report and give you the opportunity, if you want it, to have a supplemental hearing where you can talk about the evidence that that report includes. One final area, and there are many more, but that I will mention, is there will often be a medical expert or vocational expert at your hearing. You have a right, even though you're there without an attorney or other non-lawyer representative, you have a right to cross-examine those experts. And so at the conclusion of asking the medical expert questions or the vocational expert questions, the administrative law judge should turn to you and say, now Mr. Claimant or Ms. Claimant, it's your turn. You have an actual, absolute right here to ask questions of this expert, and even really should give you a little bit of help on how to do that. But at a minimum, the judge should give you the opportunity to ask questions of those experts. And if the judge doesn't do that and just moves on in your case, you probably have a very good ground for having your case sent back. So it may become evident to you from this discussion that you're really better off not doing a hearing on your own. But if you're in that situation where you didn't have a lawyer or other representative, these are some of the things you might consider in trying to get your case sent back for a new hearing.
If you have a question or comment about this video, please send us an email to webclients@herdandsmith.com. We also welcome your questions on Social Security disability. Send us an email and we will reply with an answer. We may even answer your question in a video. For a free consultation with disability specialists who can help determine if you are eligible for Social Security disability benefits, call us today toll-free at 1-877-435-3737. To learn more about Social Security disability benefits, visit herdandsmith.com to download our no-cost disability guidebook.